The Institute.
Institute for Justice.
The National Law Firm for Liberty.
Hello and welcome to Short Circuit, your often bi-weekly podcast on the federal courts of appeal. I'm your host, John Ross, joined today by IJ attorneys Robert Everett Johnson and Paul Sherman. This week on the show, compelled masturbation, a lying prosecutor, a jailed glider pilot, and state eminent domain reform. Paul, kick us off.
Sure. So parents, if you have kids in the car, this first case gets a little bit graphic. The case is Sims v. Labowitz, and it involves an allegation by a young man who was arrested for sexting with his teenage girlfriend. So this guy was 17 years old. His girlfriend was 15 years old, and he was alleged to have sent some sexual recordings and photographs of himself through his cell phone to his girlfriend. So based on this, Detective David Abbott, who's investigating the case, goes out and gets a warrant to take photographs of Mr. Sims' penis, takes the kid to a juvenile detention center, takes him to a locker room where he's surrounded by a couple armed police officers, orders him to drop his pants, takes photos of his penis, and then also orders him to masturbate so that he can achieve an erection and they can take photos of his erect penis so they can compare it to the sexting videos. So a terrible set of facts, obviously very traumatic for this young man, and he files a lawsuit under Section 1983 saying that this violated his constitutional rights. And of course, if you've listened to the Short Circuit podcast frequently, you know that this case is going to involve the issue of qualified immunity, whether it was clearly established that ordering this young man to masturbate in front of two armed officers was clearly unconstitutional.
And often qualified immunity decisions come down to this question of, is there an opinion that's directly on point? Courts will do these crazy things where they'll say, well, sure, there's a decision saying you can't shoot a man in the back, but is there a decision you can't shoot him in the back while he's also eating a burrito, and the court will say, well, but that was not clear, so this is qualified immunity, and here there, as you might expect, there's not a lot of decisions saying that this kind of thing is unconstitutional because it really just doesn't come up very often.
Yeah, and thankfully the court recognizes this, and there's a happy ending. The court finds that there is no qualified immunity for the police officer. And what it recognizes is that the most egregious types of behavior that we see from police officers, there is going to be no precedent for because we just don't expect cops to go around doing this sort of thing.
But then I guess the sort of other issue in the case comes up that the officer's sort of response to this is, or at least his attorney, the officer actually, it turns out, is now passed away, but the officer's estate's response is, well, he had a warrant and he'd gone to a magistrate, and a magistrate had approved this. And if you have a judge, put judge in quotes because apparently the judge is not actually an attorney, but if you have a judge who approves this kind of thing, doesn't that mean it's okay?
Yeah, and this argument was persuasive enough that there's a dissent in the case from one of the judges who just says, look, the guy went out, he followed all of the proper procedures, checked all the boxes he needed to check before he could order a 17-year-old to masturbate in front of him. And so he should be entitled to qualified immunity. And I think what this really highlights is the problem with other immunity doctrines in the law, because here we have a situation where not only did a magistrate judge sign off on the warrant, but the investigation was authorized by the district attorney. And the problem is that both of those people have absolute immunity, not even qualified immunity. You can just never sue them for their egregious actions. So as a result, the police officer is the only person that you can go after in this kind of case.
Yeah, and I guess, there's sort of an interest in having there be somebody who can be held responsible, especially because I think when courts created this sort of doctrine of holding police officers responsible for executing a warrant, part of what they understood was that often it's not going to be the officer who ends up paying the actual judgment. And so this whole doctrine of officer liability is in some ways a way of holding the state itself responsible. And at the end of the day, whether it was the officer or the magistrate, the purpose of this is to have somebody in the state who's answerable for these kinds of actions.
Yeah, and I think, it's fortunate that we're at a point now where I think the legal community is starting to take a harder look at these immunity doctrines. We're starting to see new scholarship questioning the historical validity of qualified immunity. And I think we've heard rumblings from people on the court that maybe we need to take a harder look at these things.
Yeah, and that's really what's so amazing about this case. I mean, these facts are so outrageous that I think a sort of man on the street would say that this can't possibly be right. And yet, in the context of qualified immunity, this is a very difficult case. And this is a case that not only requires extensive analysis, but also draws a dissent. And that really, I think, says something about where we are as a legal community right now, or where the law is on these immunity issues, that the kind of thing that you have to show to overcome qualified immunity is just staggering.
Yeah, but it's a standard that was met here.
Yes.
Okay, well, let's move on to the next case. Rob?
So this is another case about judicial engagement in a sense, and judicial abdication as well. This is a case, it's a state criminal case that then comes to the federal court on habeas review. And so the fellow here was, as the court says, he treated his nephew like his own son, and he loved him so much that he lent him $400,000. But the court observes the feeling was not mutual. The ungrateful nephew essentially told his uncle, "You're never going to get a dime from me. Not going to pay you back." And the nephew also had a habit of pulling guns on people who upset him. So the uncle goes to his nephew's gas station to confront him about this and demand that the loan be paid. Interestingly, the uncle also brings a gun along with him. He goes into the office with this nephew. There suddenly are shots fired. There are no direct witnesses. The uncle comes out and he says, "I just shot my nephew."
Well, and he doesn't just say, "I just shot my nephew." He says, "I just shot my nephew. He owes me $400,000.
Right. And he is tried. He's convicted. And you can see how this case, as it goes to the jury, what his claim is self-defense. He says, "I went in there. I felt threatened. This is a person who has a sort of history on pulling guns on people."
Yeah, he even says he reached into, I think, like a desk drawer.
Right.
And so he thought he was reaching for a gun.
Right. And so you could see how this is, there are no direct witnesses. You could see how a jury might find this to be a difficult case, except the prosecutor puts a thumb on the scales of justice, telling the jury in his closing argument that this is the first time at trial that this person has ever claimed self-defense.
And that was a lie.
And that was a lie, exactly. Suggesting to the jury that this whole defense should be discounted because it's sort of late to the game. But in fact, this defendant has been claiming self-defense from the very beginning, including in 7 recorded phone calls that he made from the jailhouse.
That the prosecutor knew about.
That the prosecutor knows about, right, exactly. So this is a bald-faced lie to the jury. And there are decisions from the Supreme Court saying that when prosecutors commit misconduct lying to the jury, that is a violation of the Constitution. So the claim then on federal habeas review is that this was a violation of the Constitution, that this conviction needs to be overturned, and that this defendant deserves a new trial.
Yeah, and that's when he runs into the buzzsaw that is the Anti-Terrorism and Effective Death Penalty Act.
Yes, affectionately known as EDPA, which is a wonderful acronym. And this law essentially says that federal courts will not grant habeas relief unless there is a violation of clearly established law. And clearly established law doesn't mean just, like in the qualified immunity context we were just discussing, some things are just obvious. No, it really means like it has to be a decision of the Supreme Court has said that this exact thing is unconstitutional. Otherwise, you're out of luck. So this is like qualified immunity on steroids.
Yeah, and it creates the same kind of problem we were discussing with qualified immunity, where usually there's not a case on point for the most egregious kinds of conduct because it happens so rarely. And unfortunately, that was the situation here.
Yeah, exactly. And so that what the court says, I mean, you read the court's decision and it is clear that they think this is bad news. And they even say, if this case was before us on direct review from like a federal conviction, that we would order a new trial. But because this case is governed by, or we might order a new trial. But they say, because this case is governed by EDPA, our hands are tied and there's nothing that we can do. And the case actually draws a lovely little concurrence from a judge who says, look, I agree, our hands are tied. EDPA plus the Supreme Court's decisions construing EDPA require this results. But the judge refers to this as judicial renunciation of the ideals upon which this country was founded. Very strong language. And really a sort of remarkable admission from a judge that these kinds of doctrines, tying the hands of courts, requiring them to not conduct their real judicial function, are a departure from the proper role of the judiciary.
Yeah, and these are often my favorite kinds of opinions, opinions where judges concur to explain why they hate the fact that they are bound to decide the case the way they are. It kind of goes to the notion that if you like the outcome of every case that you decide, you're probably not a great judge, but it's also a good opportunity for them to flag for the public and for higher courts the real problems that people are facing because of these decisions.
Okay, let's move on to the next case, which comes out of the Fourth Circuit. Paul?
Yeah, so this case has some fun facts. It involves a retired engineer named Robin Fleming, who was a glider pilot. And one day he decided he was going to go flying. And so these gliders are not self-powered. They have to be towed up into the air by another plane. But then once in the air, they can apparently stay up for quite some time. So he was flying, and he flew over a nuclear power plant, which was legal. It was not restricted airspace. And then he started to circle near the plant in this process. It's called thermaling, which allows the glider to gain altitude. By turning on these kind of rising currents of air, you can move back in the air, higher up in the air, and stay up in the air longer. Not entirely surprisingly, this got the attention of the people at the nuclear power plant who were concerned that something was going on. They contacted the police. The police contacted the airport, who got in touch with Mr. Fleming on the radio, and they wanted him to come down. The airport said they couldn't order him to come down, only the FAA could do that. So the police contacted the FAA. The FAA said, this guy's doing nothing wrong, so we're not going to order him to come down. And then the police just insisted on getting on the radio and ordering him to come down, which he did, after which he was arrested. He was held in custody for about
24 hours.
Yeah, for about 24 hours. He was interviewed by Department of Homeland Security and the FBI. And then ultimately he's charged with breach of the peace.
By the local police, not by the feds.
Yeah, by the local police. The feds don't think he did anything wrong.
Yeah, I mean, there's something sort of interesting about this. I mean, I think on the one hand, as Paul sort of suggested, it's not entirely surprising that the people at the nuclear plant got a little nervous about a plane circling above the plant. And it's not entirely surprising that the police got nervous. On the other hand, everybody then calls the FAA, and the FAA says, well, look, this isn't restricted airspace. He's not doing anything wrong. This guy was not doing anything wrong. He's peacefully flying an airplane in airspace that is not restricted. And, if this is a concern that we don't want people to be doing this, then perhaps it shouldn't be open airspace. But it is open airspace. So, what's the big deal, I guess, is the question.
Yeah. So anyway, a couple weeks later, Fleming is talking with his lawyer. He's preparing for trial. And the lawyer pushes him to sign an agreement releasing the sheriff's office from civil liability in exchange for dropping the case against him. And he resists this at first. His lawyer really pushes him. She says to him falsely, as it turns out, that they had to scramble F-16s because he was in the air. And she really seems to be kind of twisting his arm into agreeing to this settlement, which ultimately he does. He writes a 2-sentence settlement that says, I agree not to go after you now or in the future for civil liability, and you'll drop the charges against me. The agreement is validated, but then a few months later he has a change of heart and he decides, no, I think my rights were violated, and so he files a federal lawsuit.
Yeah, and so the question that the court is really addressing here is this waiver of his right to sue for the violation of his constitutional rights, is that a voluntary waiver that can be enforced, or is it something that was obtained through coercion? And the court basically says, well, you had a lawyer. Not only do you have a lawyer, but it doesn't appear that anybody really kind of twisted your arm in any kind of overt way. So this is a voluntary waiver, and we're going to enforce it. I think what's sort of interesting here is you really can think about this as a case that falls under the doctrine of unconstitutional conditions, which is a doctrine that we've litigated under here at IJ a number of times, and that I think is one that it's both under-theorized, it's sort of understood, if you can put it that way, in the courts, but it's one that I think is increasingly important in our society because the way government operates today, government obviously imposes a lot of rules overtly, but increasingly government also operates through these kinds of agreements that it obtains, often in exchange in circumstances where people feel like they don't really have a lot of choice. And we see it in the forfeiture context constantly, where people are agreeing to sign various things to get back property that's been seized by the government. We see it. We have a case in New York about people who were forced to sign agreements under threat that otherwise their businesses or homes will be shut down by the police. And we see it in all kinds of other contexts where people are agreeing to all kinds of really sort of interesting and troubling things to avoid criminal liability, to avoid civil liability. And as the sort of number of things that you can be prosecuted for expands, the government's ability to impose these kinds of conditions only grows further.
Yeah, and unfortunately, the court in this case doesn't really grapple with that issue at all. It doesn't view this through the lens of unconstitutional conditions, and it basically just says, look, this was an educated guy. If he wanted more time to consider it, he or his lawyer could have asked for more time. They didn't do that, so we are going to uphold this waiver, and his case is dismissed. So, unfortunate outcome for this guy, but it does, I think, highlight some of the problems with this kind of negotiating. Because really, like, when criminal charges are on the table, that's negotiating with a gun on the table. I mean, that's not a real negotiation.
Rob, our final case involves something that's squarely in IJ's wheelhouse. That's eminent domain for private use.
Yeah, so this is a state case out of Colorado, and it involves a taking, kind of an interesting sort of twist. It's a taking not just by a developer for private use, but also from a developer. So a little different.
Yeah, and I got to say, most of my practice is First Amendment law. So as someone who doesn't regularly practice in the area of property rights, the facts of this case just totally blew my mind. Like, it never would have occurred to me in a million years that this sort of thing can happen. But Rob, why don't you explain what happened here?
All right, so you have a town that wants to develop a area into a new subdivision, and they initially are working with developer one, and developer one goes through the initial permit process, gets part of this sort of necessary regulatory approvals and all the rest of it, but isn't able to acquire all of the land that they need for the development, so eventually kind of lets this languish.
Yeah, the only thing they get is, so there's 3 parcels, and they get this narrow strip of land that's between the 2 parcels. So
right.
they own that, but they weren't able to get the parcels on either side of it.
Right, and this is called Parcel C. So in comes developer number 2, and developer number 2 is able to acquire parcels A and B, the rest of the land that they need, but they don't have parcel C, which is still owned by developer number 1. And so developer number 2 comes along to the first developer and says, we'd like to buy that piece of land from you so that we can kind of take over where you left off.
Yeah, for $45,000. And developer 1 is like, we sank a ton of money into developing this project, into getting all of the approval. This strip is way more valuable than that because of all the work we put into trying to get this town to approve this subdivision. So you're going to have to come up a lot if you want to buy this strip of land.
Yeah, they basically saying, look, you're piggybacking on all of our work, and we still hold part of the key to this project, so we want to get a piece of the pie, essentially. And developer 2 says, well, that's all well and good, but we think we're just going to take this property through eminent domain.
Yeah, and here's the really bonkers part that I didn't even know could happen.
Right, so developer number 2 obviously is not a government, has no power of eminent domain, but that apparently does not stand in their way. Instead, they form a quote-unquote district, which is a new municipal entity, which encompasses parcels A, B, and C, but nothing else. And then they elect a government to this district, which consists of employees of the developer.
Developer number 2.
Right. And then this new district, this new government entity, decides that it will use eminent domain to seize this parcel of land from developer number 1. And
this is after, by the way, the town officials say they want nothing to do with eminent domain.
Right. And so the town doesn't have to have anything to do with eminent domain because now there is this new government entity, this district, which essentially is the developer, but suddenly now as a government is able to exercise eminent domain to take this property.
Which is just absolutely nuts. This was mind-boggling. I went and I actually looked up the statute, and I was astonished at how easy it is to create these new kind of special municipal districts that have the power of eminent domain. And it was really frightening. So developer number 1, developer number 2 initiates the condemnation, and developer number 1 tries to defeat the condemnation, and they lose in the trial court.
Right. And so the question here is basically, is this taking for public use? And so this is in state court. Colorado has a post-Kelo reform law that essentially tries to, I think listeners are probably familiar with the Kelo decision, which essentially said under the federal constitution, there is no public use, no real public use limitation on the takings power you can take from, one private party to give to another private party. People were absolutely incensed by that, and states all across the country enacted laws to basically say the opposite. And Colorado is one of those states. So Colorado has this very meaningful eminent domain limitation. And so the developer whose property is being taken says, look, this isn't for a public use. You're taking this property to develop for development purposes, which is a sort of quintessential private use. And the response, which is sort of interesting from the developer number 2 is, well, yes, we want to build a development, but we're going to use your specific narrow parcel of land for a road. And so even though this whole thing is for the private purpose of development, your particular land will be a road, so it's for a public use.
Yeah, and there's another aspect that's related to public use, which is that the taking also has to be necessary to effectuate the public use. And this is moxie here, because the developer number 2's argument on necessity is, well, we know it's necessary because we issued a statement of necessity, and that is totally definitive, and the court cannot look behind that at all. And thankfully...
Well, and you can see how this is all just completely open to manipulation, right? Like you have a huge area of land that you're going to develop, and you have a holdout and that holdout could either be a road or it could be a house or whatever it is you want to develop. And, if you're kind of at the drawing board stage, you can have the road go through the holdout's place, and so that then it becomes a public use, and you get around this limitation. Because there's no real necessity that the road be there as opposed to somewhere else, because there's nothing there yet. But it's all kind of up in the drawing board stage and easily manipulated.
Yeah. So the trial court totally buys this, and quite literally rubber stamps the findings of fact that developer number 2 wants, literally adopts them verbatim. And so, of course, developer number 1 loses. But luckily, we get an engaged panel on appeal.
Yeah, and this is really a beautiful decision. What it really comes down to is saying we are not going to allow this kind of circumvention of the public use limitations. That what's going on here is, at bottom, a private developer using an alter ego, the court uses the word alter ego, government entity to take property to further its own ends. And this is a sort of quintessential private use. It's to basically advance the business interests of this developer, and that is exactly what this reform law was designed to prevent.
Yeah, and the court also takes notice of the obvious conflict of interest that the so-called government officials of this district have, because all of them stand to benefit financially from the taking of this property and the building of this development.
Yeah, definitely a wonderful decision. And the court really sees through this sort of attempt to say, oh, well, if it's for a road, it's always for a public use. And they say, look, this is really one step removed from that kind of a situation, because you're not going to even have the road unless you have the development. And so the purpose of taking it to build a road is to allow the development to occur. not to build a road to service people who are already there. And so all of this taking sort of together is really all just to create this new development, not to provide some sort of a public service for people who, importantly, don't even live there yet.
Yeah. So, it's a good, engaged decision from the Colorado Court of Appeals. Hopefully, higher courts, including the U.S. Supreme Court, will take notice and revisit some of this bad federal precedent.
Wouldn't that be wonderful?
Okay, that concludes the show. Thanks for listening, and be sure to follow Rob and Paul on Twitter. Their handles are @FreeRangeLawyer and @Paul M. Sherman. Until next time, this is John Ross from the Institute for Justice, hard selling you to get engaged.